Are you aware that this bill, if passed, could get us eerily close, if not over the line as far as Title IX, and we could potentially lose $1.3 billion in federal funding?
Representative, in 50 years of Title IX, no school system, no LEA has ever lost federal funding due to a Title IX violation. And I would argue to the exact opposite, that there is far more court precedent in favor of protecting a teacher's First Amendment rights than in favor of the current administration's opinion of Title IX. So I would certainly take my chance in the courts on that one.
Follow up.
Thank you, Mr. Chair. And that Title IX, it transcends present administration, conservative, liberal, anything. Title IX has been the law. I'd argue with you that the reason that when Title IX, if you look at the United States when Title IX was enacted and the United States today, it's because of Title IX and compliance with Title IX, strict compliance with Title IX, that we have women's athletics the way it looks like, and just general equality. So again, I will ask, because when the government passed a law, it's our job to enforce them. So I'll ask this a different way. Do you feel that it's good governance to impose a law that is extremely risky to every life, every Tennessean, every taxpayer in Tennessee's financial position?
Leader Cochran.
Thank you, Mr. Chairman. Well, Representative, if you want to talk about the law and you want to talk about the courts, let's talk about that precedent just a little bit. And specifically the Sixth Circuit Court of Appeals, which governs, the state of Tennessee is within that jurisdiction. The Sixth Circuit observes that if schools can require a teacher to speak, if a school can require a teacher to use, can require a teacher to call a male student a female, which would be against their core beliefs. If they can do that, this is a direct quote from the Sixth Circuit Court of Appeal, they can also require a pacifist to declare that war is just, a civil rights icon to condemn the Freedom Riders, and a believer to deny the existence of God, or a Soviet to address his students, a Soviet escapee to address his students as comrades. Essentially what they are saying is you cannot force someone to speak. That not only does the First Amendment protect your right to speak, it protects your right not to speak. You cannot be coerced to agree with something that is against your core values. That has been upheld in court multiple times in the Sixth Circuit and in other places in this country. So if we want to talk about court precedent, the precedent is certainly on the side of this bill.
Let's now go to Representative Fritz.
Thank you, Mr. Chairman. To the sponsor, I appreciate you bringing this bill. Just a quick question for you. I'm assuming you believe in absolutes, absolute rights, absolute wrongs. And I'll follow that with a question before you respond, please. Would it be the right thing for us to do to grade a math paper, and when the test was, when the problem was 2 + 2 = 4, would it be okay to suggest that it's 5 just to placate someone's sensitivities to that?
Thank you, Mr. Chairman. Representative, I believe that would be a very dangerous precedent and not the correct action to take.
Thank you. And members, also, when we're discussing bills like this, I hope everyone's read. It's only a page and a half. I hope you book, chapter, and verse each one. I'm reading through this, and please correct me if I'm wrong, Leader Cochran. It just talks about the rights of the teacher, protection of the teacher. It doesn't say anything about discrimination against a student. Am I wrong in this?
That is accurate, Mr. Chairman.
Thank you. Representative Jones.
Thank you, Mr. Chair. I'm sorry to you all for how my colleagues are acting toward you. I'm sorry about how the men behind me are acting, because what we're seeing is bullying from those elected to serve these people in the audience. What we're seeing is people using their power to hurt the most vulnerable students in our community. And so,
Representative Jones, we have a point of order. Chairman Reagan, you recognize.
every time I talk, we call point of order. We turn off the microphone, but I'm going to have questions to ask. You do not point of order anybody else, so let me ask my question.
Sir, let me recognize Reagan. I will come back to you. Chairman Reagan.
Thank you, Mr. Chair. The point of order is this is not on the bill that's before us. Speaking to the audience is not on the bill. If he wishes to direct comments or questions to the sponsor, we are in order. Otherwise, we're not. I submit to the chair's ruling.
Thank you very much. Representative Jones, do you understand the point of order was made? We stay on the bill.
Talking to my man all wrong.
I know we all have a worldview and a 360-degree view of things, but we can't go around the world whenever we're trying to express.
Yeah, okay, big guy.
Stay on the bill, please.
All right, thank you, Mr. Chair. Mr. Smalch, I have a question because I feel like you've misled this committee. You stated that the Sixth Circuit case, Meriwether v. Harthrop, gave K-12 teachers the right to misgender students. When that case explicitly states from the court, if you read it in full, let me finish my question if you don't mind, that it shall not be applied to K-12 teachers. Secondly, if you read Meriwether in full, you'd know that it explicitly states that if it only applies to university professors, and that even when professors have the First Amendment rights, it's still analyzed on a case-by-case basis dependent on how efficiently the school is providing its services. That is the case you cited, but you misled this committee and gave us a wrong context and definition. Is that correct?
Chairman Cochran, you recognize, sir.
That is incorrect. Meriwether does apply to a public school. It refers to a public university, an employee at that public university expressing or not being forced to speak on something. And again, we can talk about Pamela Rickard versus Geary County School Board. We can talk about Cross versus Loudoun County School Board. We've got multiple cases that back up this bill. So, I mean, if we want to get into a legal debate, we can talk about legal precedent. But Meriwether is certainly about a public school. It is a institute. It is a university. With that being said, it is about an employee at a public institution not being forced to speak. And it is clear on that you cannot force a public school teacher to say something that is against their core values. And I believe the court is very explicit on that, and I believe it would apply to this. Regardless if it does or not, however.
I was recognized, correct?
Let him finish his statement, then I'll come back to you and recognize you. Leader Cochran.
The members of this body also certainly stand for the First Amendment and the protections of the First Amendment, and it is our priority to do that. But I do believe that this court case backs that up, and that we as individual representatives also fight for the First Amendment, and that is within our right to vote to reaffirm that in our code.
Representative Jones, follow up.
Thank you. I'm going to stay on the bill and not talk about how this body's banning books. If we want to talk about the First Amendment, I won't get into that. But what I will get into is some questions about free speech. You state that this bill is about free speech, but does it protect teachers who want to properly gender students as well? Because all I see is about misgendering students. Does it protect teachers who want to properly gender their students as well, if it's about the First Amendment, quote unquote? Leader
Cochran.
I would recommend you read the bill again because it does not require a teacher to refer to a student based on their pronouns that are on their permanent records. It allows them to. So that the teacher can do that, or they can choose not to. So no, it doesn't require them to.
Thank you. Where is this a problem? Where have teachers been fired in your school district for using the incorrect pronoun? Where has this been an issue in your district?
Leader Cochran.
So again, there have been issues throughout the country, Meriwether being one of those cases. And again, there's cases in Virginia, Kansas. There is confusion in Tennessee. I've spoken to teachers in my district who have had that question, and districts are not sure that they are unclear. They feel like they do not have that protection currently under the law. And so, yes, I think it's very critical that we provide that clarity in the code. Absolutely, there's confusion in Tennessee.
You may have one more follow-up.
Thank you. If a teacher, say, wanted to refer to me by the N-word, would that be okay under your free speech definition? Would you be okay with that?
On the bill.
Oh, this is about the bill, Mr. Speaker. Mr. Chair.
No, it is not. Chairman, Leader Cochran, you can address that, then we're moving on.
Of course not. That's ridiculous.
Just like the bill. Thank you.
Thank you.